Welcome. I'm AdaKay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Good afternoon. Good morning. Good morning. Good morning, everybody. We are in two trials today. I'm AdaKay. I'm your host, and we are going to be watching on this live King's hearing where Rosemary Scapicchio, I don't know how to say her name, is going to whoop some butt. So anyway, I have a second live going on right now on another live, and that's okay. So if you see me pop in and out kind of like this, it's because I'm on the other live. But right now I'm on live with you, and what we're gonna do is we're gonna get in the hearing. I know I'm a little late, had a hard time finding the live feed. We found the live feed, so we're here for the show. So let's get to it, everybody.
Who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney Lamacchia. My biggest concern is whether or not it's been communicated to the U.S. Attorney's Office and or the federal judge that you and Judge Fournier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney Lamacchia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of is that being discussed amongst the things that need to get resolved, because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week and then all of a sudden someone says now we need the order. So to the extent
I would like to see the February order.
And I conveyed that to them.
But I also have to deal with the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders, but we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together.
Judge, I appreciate that 100%. My concern is if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that.
Yes.
And I invited you the last time to seek to intervene or to
Judge,
do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was, if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So
Okay.
that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure.
Yes.
Okay. So we'll put, let me just see, we will put,
Except for Mr. Wester, I do want to say, who will still be on vacation.
right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh
Yes, please.
on for 2 o'clock on the 12th on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you,
Okay.
Honor.
And
All right.
is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're just dealing with the issue of the late disclosure. And
May I be heard, Your Honor?
sure.
The close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that this has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently. And then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process.
That's
I
right.
don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from Ms. Scapicchio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table. It's the third. If you look in the manila folder that's underneath that, there, in a rubber band, it's in your hand right now.
Oh, in here, okay, this one.
That, yes. The third doc,
Okay,
that is what I prepared with the assistance of ADA Hickman.
okay,
Which specifically describes what, if anything, is
okay,
minorly different. That was provided to council on Thursday last week. We met we got a teleconference on Friday, and council was working on their own lists.
okay,
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading what council disagreed with, but that was not reached. We provided you, the Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date. But at this point, I know ADA Hickman has worked very hard
All right.
to go through the material.
Attorney Scapicchio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth's chart and your chart.
Yes,
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure
Well,
out
Judge,
a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on
And
Friday.
do I have a list of the items which are new or which you claim to be new, and that I can then cross-reference against the Commonwealth's list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance.
Yes, Your Honor. I
Okay,
am.
where will I find that?
So where will you find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had
Okay.
between now and the last
All right.
hearing.
All right. So you need more time to get the other stuff
I
done.
do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. Because I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand. But if we don't have everything and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say, this is,
Well,
now this
as
is
an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
yes, sir.
That's what I think we were shooting for. We
And that-
understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a bait stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes,
You were referring to lots of stuff which is not in the record,
Correct.
right? We admitted in the last hearing exactly 1 document,
yes.
right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit. And then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient. And then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thank you.
Oh, I'm sorry.
All right. So I've been handed 3 charts. Chart 1, chart 2, and chart 3. You're moving their admission?
Yes, Your Honor.
Okay. Any objection, at least for the record here?
No objection.
Okay, so these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
And may I admit the Commonwealth's exhibit? the chart.
This is the Commonwealth exhibit.
Yes.
Any problem with this?
No, Your Honor.
Okay, so this
They
will be
were-
exhibit 5.
Thank you, Your Honor.
Thank you. All right, how do I deal with these charts? How do I read them? They look like you're talking past each other to some extent, that they're not, so if I look on exhibit 2, which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone, draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does it show? Document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized. So the Commonwealth is claiming, so for the first 2, Judge, if I can just show you. For the first 2, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was
No. Just slow down. I want to understand what Exhibit 2 shows.
so Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're
from the
quoting
Commonwealth.
something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents, to try to convince the court that we already had them. There's search warrant stuff down there. The 2.
Okay,
Give me the-
and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the bait stamps in the ones that we did. So if you look down to the second column, we do have bait stamps. There were some things that were given.
Second column,
I mean, the second part of the chart, we were able to provide bait stamps.
second chart? Or
No,
this?
just where it says notice 4925.
All right, so how do I compare what you have to what the Commonwealth has provided me? I need you to be on the same page. I need you to go through every single document that was produced that you base your motion to dismiss on. Every single one.
Mhm.
You have to address every single one, okay? And you have to make a chart saying this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand
Okay.
now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay?
Okay. So I understand the scope of the problem. And then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than putting Mr. Lally back on the stand or anybody else. Because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And so you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but I think we need to do this in a logical order.
Thank you, Your Honor.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th.
I don't
But
know
the
where-
12th would not be for evidence. It would be for an explanation of the analysis that you've done on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could.
I'm happy to report back at 2, Judge, if that's what you
Yeah.
want us to do.
I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think, frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event, and it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new.
Mhm.
And then I need to hear from defense counsel document by document as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're none.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't notice we were addressing that today.
Would you like to be here on the 12th also?
I would need to check, but if I could be available on the 12th, but that would be a better date than today.
Okay.
You want to
If I
check?
can just double
You have
check.
your calendar?
Sorry,
You have your calendar?
I'd have to just call my office.
Okay. Let's put it on for the 12th. Call your office. If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available at 2. I believe I can be available at 2. I have to double check if I can.
Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk.
Okay, so it looks like we're going to be back here on the 12th. And that's the end of this. Wow, guys, this is going to be interesting. This is going to be spicy. I'll do a breakdown of this on the other live. I'm on a live right now with the wife dismemberment trial, the Georgia versus Nicholas Casotis trial. And during break, we will break this down during our break on this trial. Thank you so much for joining us for this hearing. We will see you guys again on the 12th. Have a great afternoon. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.